The next speaker is Gabriel. Gabriel, thank you for joining us. Gabriel, you are coming from Brazil. Gabriel Bathasar Pedraza, you are a professor teaching constitutional law in Mexico City at the University of Hidalgo. And you are also the founder and the president of the Generation X, which is an NGO fighting against discrimination. You are also an abogado, a lawyer practicing in Mexico in tax, in constitutional law, and for human rights. So, Gabriel, thank you again for joining us today.
Thank you, Aban. I'm very excited to be part of this panel. It is a very interesting question. The first thing that comes in mind is recently in a New York Times piece, I read a story about Justice Ginsburg. She was once visited by a woman, a law student, and she said to Justice Ginsburg, "Oh my God, I'm so excited. All my feminist friends love you." And Justice Ginsburg replied, "I hope your male friends love me as well." And what I'm going to say is that we do. We actually do, and we have very good reasons to love her for her work, for her inspiration. So in order to talk about this topic, I would like to talk about first about her legal strategy when she was a litigant for ACLU, as Alberto previously mentioned, and also Vanessa. So what she did when she was a lawyer back then is that she attacked, she challenged laws that were designed to protect women, but they were based on very archaic and stereotyped notions of the roles of men and women in society. So this strategy, in my opinion, had two reasons behind it. The first one, which is awesome from a litigant's perspective, is that she was trying to persuade a court that was full of men about discrimination against women, especially that the Equal Protection Clause on the 14th Amendment also prohibits discrimination against women. So this was very important, but also she was trying to prove that this type of laws that establish or reinforce the stereotypes of men and women were hurtful for both, for men and women, because they reinforced, as I said, this notion that there were certain type of works, certain types of roles within a society for men and also for women. So for instance, in a case named from Tiero B. Richardson, which was already talked about, so I'm just going to talk a little briefly about it. It was about a lieutenant in the United States Force. It was a woman named Sharon Frontiero. So she was married to some man, and she was claiming that he also deserved to have a pension and an allowance, which was only accessible for women. So the court agreed with Justice Ginsburg, and they invalidated the law because it violated the Fifth Amendment, because the due process clause on the Fifth Amendment, because it was completely arbitrary to give a different treatment to women and men. So this is important in my opinion, because it goes to show that men can also be dependent on or have a different role within the family structure, and that it is not our job always to provide. And this gives us men a very great sense of freedom, not to be to feel constrained by the role we're supposed to have within a family. So then again, in Reed versus Reed, Justice Ginsburg, representing a woman named Reed, um, uh, she claimed that the Idaho probate code that established that males must be preferred to females in appointing administrators of states. She claimed that it violated the Due Process and Equal Protection Clause. So the court agreed with her. And for me, the important part is that this type of role that the law usually reinforces, that men are better administrators, and that we have to have this role in society of providers and administrators. It's obviously archaic, and it not only affects women because it excludes them from having this type of role, but also it constrains us and us men and makes us feel obligated to have this type of role, even though we might not want it, even though we might consider that somebody else within our family can have this role and do it in a better fashion than ourselves. And finally, it's a Weinberger versus Weisenfeld case. This was about so there was a couple, they were married. The woman died in child labor. So Mr. Weisenfeld applied for Social Security benefits, and they were denied because only women had access to this type of benefits. And the court invalidated the law because it violated the Due Process Clause in the Fifth Amendment, because it discriminated against men, but not in the way that men that oppose feminism usually argue, right? That the laws that protect women are inherently inherently discriminate against men, because this is, in my opinion, obviously not true. But it is this particularly type of law that is based on stereotypical notions of men and women that actually discriminates both against women and men, but not because it favors women. It is because it reinforces these notions, these roles about how women and men should behave within a society. So yeah, well, again, when she was a justice in the highest court, she wrote the decision in Virginia Military Institute, well, United States versus Virginia, where Virginia Military Institute, that was an institution reserved only for men, was sued by the federal government, United States federal government. And well, the question here was whether this institution reserved only for women only for men, violated the 14th Amendment Equal Protection Clause. And the court, in the opinion wrote by Justice Ginsburg, said it actually violated the 14th Amendment. And I would like to read a very brief portion of the decision. I think it illustrates very well what the topic I was referring to. And it says, inherent difference between men and women we have come to appreciate remain a cause for celebration, but not for denigration of members of either sex or for artificial constraints on an individual's opportunity. Sex classifications may be used to compensate women for particular economic disabilities they have suffered, to promote equal employment opportunity, to advance full development of talent and capacities of our nation's people. But such classifications may not be used as they once were to create or perpetuate the legal, social, and economic inferiority of women. So the day after Justice Ginsburg passing, I was teaching a con law class, and I usually pose a I pose a question about discrimination in a public university. The case is very similar to Mississippi University for Women versus Hagen, which was decided by the opinion of the court was written by Justice O'Connor. The case is about a university that has a program for nursery, but it only admits women. So there is a man that applies for the program, and it is denied only on the basis of sex. So whenever I ask this question to my students, does this action violates the equal principle, which in the Mexican Constitution explicitly prohibits a different treatment based on gender? Most of my male students agree. They said, yeah, it obviously is unconstitutional. It violates the Equal Protection Clause on the Mexican Constitution because it discriminates against men, because it gives more opportunity to women. And there's also some women students that said, no, it's not discrimination because there's a good historical basis to have this program only reserved for women, because it gives us a better chance to have a professional and university education. But at the bottom of the problem, it lies the question, or the topic we were talking about, that this is actually unconstitutional, but not because it discriminates against men and because it gives a better opportunity for women. It violates the Equal Protection Clause because it reinforces these stereotype notions that there are certain jobs reserved for women, such as nurses, and also excludes men for this type of jobs. So this goes to show how the system, this type of legal system, is hurtful for both men and women. And what Justice Ginsburg did was that she totally transformed the legal theory behind the feminist movement against this type of law, but also showed to the general public that this affects both men and women. And finally, on a personal level, I would like to say that I admire Justice Ginsburg deeply, because she had the vision to understand that it was not enough to be fighting for the good cause, which is obviously fighting against discrimination against women, but also to translate this in a language that the judges and justices were able to understand. And from a litigant's perspective, such as myself, we always faced in this type of cases this challenge, because we try to persuade a group of very privileged men and sometimes women that the cases we're working on, which we usually represent people that live in completely different circumstances from the judges, they are actually being hurt and discriminate And this is always a very difficult to explain to judges. So it is not, as I said, it is not enough to be fighting for the good cause. You have to have a good legal strategy, and she had it. And actually, she changed the legal system, fighting within it, and she has my deepest admiration for that. So that's what I was going to say about.